And I see people joining us. Amazing. And we are officially live on YouTube. Amazing. We are all good to go. Everyone, thank you. Welcome to Family Law Now After Hours. Today's topic is do's and don'ts of self-representation. More people are representing themselves in family law matters, sometimes by choice, sometimes by necessity. Self-representation can save costs, but it also does bring procedural traps as well as legal risks. Really, the key is preparation, knowing courtroom etiquette, deadlines, available resources that you can have at your disposal, and when to get targeted legal help. If you're joining us today via Zoom, you're able to use the Q&A feature to submit your general comments and questions about this topic. Unfortunately, if you're joining us via YouTube, you will not have that opportunity. But it's really important for those who are submitting questions today. If they are specific questions about the details of your family law matter, those will not be answered. We won't be answering general questions and comments today. But please feel free to contact our team directly so we can assist you. The purpose of this series is to discuss general information on separation, divorce, and other family law matters, and any information provided here should not be construed as legal advice. Stay tuned as always until the end of our segment, as we will be sharing how you can schedule a free initial 20-minute consultation with one of our lawyers here at the firm. Now, to introduce my amazing group of panelists today. On your screen, you will see Anna. Anna is a compassionate and strategic family law lawyer who takes a client-centered approach to every matter. She helps clients feel supported and empowered while navigating the emotional realities of family law. With strong communication skills and a collaborative mindset, Anna develops practical, tailored solutions that reflect her clients' goals. She is recognized for offering clear, creative guidance in moments of uncertainty, enabling clients to make confident, informed decisions. Anna holds a Master of Laws from the University of Law in London, as well as a Bachelor of Laws from the University of Sussex, grounding her practice in both advocacy and empathy. On your screen, you'll also see Michelle Snook. She has worked as a law clerk exclusively in family law since 2014. She joined RIA Collaborative Lawyers in September of 2017, and as a law clerk, she works closely with clients to draft various correspondence as well as court documents. And Michelle is committed to providing professional and compassionate assistance to clients, ensuring their needs are met with precision and care throughout their legal process. As well on your screen, you'll see the wonderful Margie. She has over 17 years of experience in family law and has been a lawyer since 2002. She is a collaborative family law practitioner as well as an accredited mediator who is passionate about facilitating fair and reasonable settlements for her clients. Margie approaches law in a holistic manner and believes that, as a family lawyer, she has a unique opportunity to provide emotionally intelligent advice to clients that will assist them in moving forward with their lives in a better position with the best interests of her clients and their children in mind. Last but not least, we have myself. Uh, I am known to be, and it's not coming just from me, it's this coming from clients themselves, word of mouth. I am a compassionate family lawyer driven by a deep desire to support families through challenging times. With a background in commerce, I bring strong negotiation, analytical, and critical thinking skills to my legal practice. During my articling period, I gained confidence in handling a wide range of family law matters. I emphasize active listening, clear communication, and empathy, fostering a comfortable environment for clients. I am certified as a collaborative lawyer with the Ontario Association of Collaborative Professionals, and thus I offer clients an alternative dispute resolution approach to avoid court. Outside of work, I am a dedicated Toronto Maple Leafs fan, as well as an LA Rams fan, and enjoy playing hockey and watching comedy movies. Love my comedy movies. And with that, let's get into our topic for today, which is the do's and don'ts of self-representation. So the first subtopic we have today is when to consider self-representation. And I mean, you'll likely hear from the two other lawyers and law clerk on this panel that ideally speaking, it would always be best suited and in your best interests to obtain legal advice and independent legal representation as quickly as possible. However, we understand that that is not always the reality and it's always not a practical option. So the purpose of today is to really discuss the do's and don'ts, and really when we're looking at when yourself to consider self-representation, I would first look at the simplicity of the case, right? So that's number one. Self-representation may be considered if your family law matter is straightforward. For example, there can be a consent-based parenting arrangement. There can be simple child support or spousal support calculations, as well as there's no significant disputes over property or there's no complex financial issues. The fewer parties, fewer assets, and the fewer contentious issues, the more feasible it may be to represent yourself. As well, number two, we look at limited financial means, which often really is the barrier to seeking legal advice. And with that, many people do consider self-representation when legal fees are prohibitive. It really is important, though, that you keep in mind that while self-representation can save money initially, there may be hidden costs, and those hidden costs often include, mistakes, delays, or needing legal advice at a later date. The third being comfort with court procedures. If you are one of those lucky individuals who is, for whatever reason, familiar with court processes, as well as court forms, so you understand the difference between a Form 8, a Form 13, a Form 14. Again, if you're not comfortable with these forms or even have any idea what I'm talking about, likely speaking, you would not be deemed as being comfortable with court procedures. But that, all the various forms, coupled with the timelines, and knowing when to file certain materials, etc., self-representation may be more viable. And there should also really be confidence in communicating clearly with judges and other parties, whether that be the other side as a self-rep, it could be the other side who has counsel retained, so being able to speak appropriately, confidently with counsel, as well as the various court staff that you may, encounter on a as needed basis throughout this process. That really is essential. The fourth I would note is that your ability to maintain emotional control. As you may or you may not know, depending on if you've been through this process or not, or maybe even what you've seen on TV, you've heard from a friend, you've heard from a family member. Family law cases can be emotionally charged, and they often are emotionally charged. And if you feel that you're able to handle negotiation, mediation, court appearances, all of those combined without letting emotions interfere, self-representation is more realistic. If you find yourself succumbing to, high stress situations. Maybe your emotional intelligence is lower. Maybe you have difficulties speaking with your significant other or your spouse that you're now separating from. Maybe there's been domestic violence issues. All these things coupled would likely not make you your best advocate. And as such, I would suggest seeking independent legal advice in that regard. The fifth would be limited risk of complex legal issues. So again, it goes back to number one, but I would advise and note to our viewers today that you should be avoiding self-representation if your case does involve high conflict parenting disputes, if there's been allegations of family violence, if children's aid or the police are involved for whatever reason, if there's complex financial portfolios, so if there's the inclusion of corporations, maybe there's multiple properties, pensions are involved, as well as international or cross-border issues. Maybe there's been an apprehension of the child internationally, an abduction, maybe there's international property. These things and these scenarios really often require professional advice to be able to protect your rights and be able to communicate to you what your best interests are. And I would say finally, um, access to resources. So the province does provide some self-help resources. At every courthouse, there's what's called the Family Law Information Center. They have materials there as well as individuals who would be able to provide you on-site assistance if you are at the courthouse. There's also court forms and guides available online. As well, there is Legal Aid Ontario. Again, the ability to retain legal aid, they have their own set of criteria. You may or may not qualify. First things first, before agreeing or wanting to proceed by way of self-representation, first and foremost, even if you think you don't apply, I would really highly suggest that you attempt to call legal aid for yourself and see whether or not, you may apply because it could surprise you. Um, and really, what I would say is that self-represented litigants do benefit from at least some professional guidance. Um, even if that is a brief consultation with a lawyer, whether that's duty counsel, for example, and just in time before your case conference or a settlement conference or maybe a motion, duty counsel is present at the courthouse, and you should be able to, or you should actively be seeking some professional guidance just before your appearance. And finally, which I'm sure will be discussed later today, is the idea of a hybrid approach. So some clients choose what's called partial self-representation. So that would be done on what's called a limited scope basis. And what that means is that they use lawyers as they see fit for certain issues. So it could be seeking advice on specific issues. It could be document review. It can be preparing your court materials. So there's a way to still be a self-represented litigant and using your funds in the most cost-effective manner as possible to still be able to advocate for your position. And this approach does really save money, and it also, which is really the key for today in helping you at home minimize risk. Because at the end of the day, you want to minimize risk as much as possible. And with that, brief, I don't want to say brief introduction because I don't think it was that brief, but with that introduction, I should say, I'm going to flip it over to Anna to discuss both the benefits as well as the challenges of going solo.
Yeah, I would say, the general theme for our conversation today is that proceed with caution should you decide to self-rep, but there's definitely some benefits to look at. When people decide to self-represent, I mean, one of the most obvious benefits would be saving money, the cost-saving benefit of not paying legal fees. Because legal fees can be a real concern, and self-representation may feel like the only accessible option sometimes. So, for some families with very simple issues, going solo may be the difference between engaging in the process at all or opting out entirely if you're the one looking to start the application yourself. Another main benefit is control. I mean, you decide when to file, how to file, what to file, and present your own story. Many self-represented people appreciate being directly involved in every aspect of the case because these issues are deeply personal, especially with parenting matters. But again, we would advise to proceed with caution with this because that can also be a con because you are so emotionally attached to the matter. There's also some flexibility here. I mean, you work on your materials around your schedule without waiting for a lawyer's availability. And some people find the process to be educational, right? There are people that are lifelong learners and could enjoy the litigation process. That being said, we've all made a career out of it, right? So it's not like it's something simple to wrap your head around. There's lots of details to learn. You have to learn the forms, the law, the timelines, and expectations. Um, but, some people can prefer to be deeply involved and find the experience grounding or educational. And I would say another benefit is that there are resources available. Joseph mentioned some of them already, duty counsel, the family law information centers, there's pro bono clinics, and these are all designed to help people navigate the early steps, even without hearing from a lawyer for the entirety of your case. Like we mentioned, there's limited scope retainers, which could be a huge benefit if you're deciding to take on this process yourself. But I can jump into some of the challenges about moving forward should you decide to self-rep. Um, Litigation can be a struggle, and unfortunately, it may be something that you're realizing you struggle with when it's already at an urgent matter or too late. So first, the system itself is not designed for the average person, right? It's not something that's easy to understand. So that's definitely going to be a challenge ahead of you should you decide to self-rep. The court relies on strict rules, complex forms, and mandatory procedures, and legal tests that aren't necessarily very intuitive. Judges do their best to be fair, of course, but they can't give you legal advice. That's only something a lawyer can do. Even when it's maybe obvious to the other members in the court that you're missing something. So there are challenges and procedural risks that you need to be aware of. Something as simple as using the wrong form or missing a deadline or filing evidence improperly can turn the case upside down. So, not responding to allegations correctly can sometimes result in it being treated as an undisputed fact. So, it's definitely a situation where you want to make sure you're not forgetting anything and that you're making your application as fulsome as possible. There's also this issue with emotional distance. Family law is intensely emotional. So when you're representing yourself, every affidavit, allegation feels personal. So lawyers kind of act as a buffer between that. We can help the client stay grounded so decisions aren't made reactively or defensively. We also see significant power imbalances when one side is represented and the other's not. Opposing counsel isn't going to try to take advantage of you. They're trying to advocate for their client, though. So this can be seen as a disadvantage to you. They understand the system better, and this can create a huge disparity in negotiations in the court. Self-representation is also hugely time consuming. You're gathering disclosure, you're preparing affidavits, you're doing research, and you're trying to organize everything. It can take an extreme amount of time, and mistakes can have long-term consequences. So, a temporary order, especially on parenting or support, can shape the trajectory of the case. So, early missteps are often difficult to undo, and these challenges don't mean you can't self-represent, but they do mean that you have to approach this very carefully.
No, 100%. Thank you, Anna. That was extremely comprehensive. Now let's switch gears. We're gonna pass it along to Margie now. So we are under the guise now that we are, gonna be proceeding by way of a self-represented litigant. So Margie, if you were in your shoe or in the shoes of a self-represented litigant, how would you advise to really prepare your case thoroughly? I know that's how the prompts noted, but what would the steps you would be taking to ensure, your best chances for success?
Well, I think we already touched upon it. Getting help from the start, even on a limited scope retainer basis. As you know, as Anna and you, Joseph, have mentioned, family law is a lot more complex than most people think. So it's really important to get help from the start. And the help that you would want to get at the very basic level, if I were, not a family law lawyer and I was in this sort of situation myself, would be to get legal advice on, setting out my theory of the case. And the theory of the case is important because that's the concise and the logical description of the events or the facts. And then you also want to know the law that's applicable to those facts. So I'm already, I think, highlighting how complex that could be when you're talking about the law, right? And when I say logical and concise, as we all know, as lawyers dealing with self-reps, sometimes they're not often concise and they're not often logical, right? So the theory of your case is really, what is your case about? What is the law that applies to my case? And, setting out a roadmap to assist you in determining the evidence that you need to set out the facts and how the law applies to those facts. Do you need an expert? Would you need an expert to testify as to for example, the value of your business? Do you need an expert to testify as to, or provide recommendations as to parenting? That's part of understanding what the theory of your case is, right? And that's all going to be packaged together in a persuasive manner that will satisfy the court that it should rule in your favor. So as a self-rep individual, the first thing you have to know is not just the facts. You know the facts better than any lawyer would know, but the difficult part is knowing the law, the various steps that you have to satisfy and what facts you have to present and in what fashion you have to present those facts in order for you to satisfy all the various legal tests that might apply to your case. So first step, get help from the beginning, even on a limited scope basis, for a lawyer to at least give you that sort of guidance. The second thing is know your deadlines. We've mentioned deadlines. There's various deadlines. You have 30 days to respond to an answer. I know Michelle's going to go into this greater detail, but it's not like the family law rules have their own deadlines, but then we add an extra layer. Some courts have their own deadlines for different things, right? So the deadlines, the general deadlines are set out in the family law rules, but practice directions also provide very court or region specific deadlines. So, family law is already complex. Here's deadlines according to the family law rules, but hey, there's this practice direction. And even, as lawyers, I don't know about you guys, but sometimes if I have a file that's given to me from a jurisdiction that I'm not really familiar with, it's like which region applies. So again, that's where a lawyer would help you, right? At least in terms of the procedural aspect, because not knowing looking up a deadline on the family law rules can help you in one respect. But if it's different in that particular courthouse where you have to go, you have to be very careful, because then, as Anna mentioned, if you don't meet those deadlines, you run the risk of having part of your case thrown out, or some of your claims dismissed, right? So know your deadlines, know your page limits. The page limits are very important, because even if you know your deadline and you've prepared your materials in a concise, logical way, and you've done it very well, if you don't follow the page limits, your materials could be rejected. So, and not surprising, every region has their different rules when it comes to page limits. Okay, again, that's where a lawyer can help you. And part of my piece in this as well is going over some of the resources available to self-reps, which we'll get to later, in addition to the ones that you've already mentioned, Joseph. So apart from knowing the theory of your case, facts, the law, the deadlines, the page limits, all the different requirements from the various regions, depending on where your matter is at. The fourth thing that I would suggest to self-represented individuals is to do offers to settle early and often. And the reason why I say that is because first, it helps you in terms of costs. So costs are the issue of if you are successful in your case and you've done an offer to settle, then you should be entitled to some of the costs or expense that you incurred to defend or argue your case. And that would include any legal fees that you incurred from a limited scope retainer, for example. And also, as a self-represented individual, there's case law that says self-represented individuals are also entitled to some costs if they're successful. And success is often determined by reasonableness. And reasonableness is determined by whether or not your offer to settle is close to what a judge eventually orders. If what you offered is just as good as or better than what a judge eventually orders, then you're entitled to your costs. If you're not successful and you've done offers to settle, that would be looked at to sort of minimize your risk for costs, right? Even though you're not successful, you did serve offers to settle, and therefore, especially if they're reasonable, that should sort of minimize your risk of costs. And the second benefit of doing offers to settle early and often is that it can narrow and usually narrows the issues. And so going back to the theory of your case, if you can, reduce or narrow the number of things that you have to argue, you're really giving the court would be, usually looks favorably on parties who narrow the issues when they go to court. You're only having to focus on fewer issues. So that's my
That's
how
your
to
spiel.
here thoroughly.
No,
Yes.
that was extremely, extremely well said. I think you really provided an easy to follow framework for those going through this path solo. So I appreciate your level of detail on that. And unfortunately, no time to have a water break, but we're going to turn it back to you again, Margie. I know we've discussed on this webinar, not this one specific, but throughout the year, we've had various sessions where we discuss certain types of courtroom appearances, whether that be what's called a conference, that could be a motion, that can be a trial. So there's various types of courtroom appearances. But really, with respects to etiquette and procedure, they're more or less relatively similar in nature. So can you please provide a understanding of what these various etiquettes and procedures are for self-represented litigants?
Well, for procedures, we don't really have enough time to go through the procedures for every single court appearance, whether a case conference, on the conference, trial management conference, or a trial or a motion. But in general, there's two different kinds of appearances, right? Be it case conference. I know settlement for conferences, the presumptive mode of the hearing is now in person. Motions, some motions in certain courtrooms or courthouses or regions are in writing or in virtual. So there could be your appearance could be in person or virtual. So the same rules apply in general to both appearances, but in in-person appearances, when the judge enters, you have to rise. Every time the judge enters or exits, you have to rise. I'm just going to give like a bullet points of like tips that I usually tell my clients as well in preparation for court. Do not speak unless you're spoken to. Speak clearly but respectfully. Be concise. Remove emotion, which again, to Anna's point, when you're the subject of that litigation, it's very difficult to not be emotional. And but do your best to remove emotion. Know your facts and the law. And again, that's where a lawyer could help you with in terms of the law that's applicable to your particular fact scenarios. Limit your talking points and stick to them. Don't talk about, how the opposing party is, she did this on a Saturday and therefore she will do that for every Saturday. Like stick to your talking points. And again, that goes back to removing emotion. And when you're dealing with, a conferences, for example, or even motions, you want to stick to like, you don't want 10 points. You want very specific, limited points that you want the judge to focus on, the most important things. As I mentioned, do not interrupt the other side, especially the judge. Don't make any snide remarks. Don't personally attack the opposing party or the opposing counsel. And one of the things that I've also learned through my career is judges love it when you say something positive about the other party. No matter how difficult that is, say something positive. She always made lunches for the kids, like something. I find that sort of softens a judge. So apart from being respectful, don't speak negatively to the best of your ability about the other party unless it's actually relevant to what you're trying to talk about. Note that everything that you are saying is being recorded as soon as you enter that courtroom. So be very careful about what you say. Because I actually had one conference where the opposing counsel said something and the judge mentioned it during the conference. So everything that's being said in the courtroom is being recorded as soon as you enter. So be very careful what you say. In terms of virtual appearances, the same rules apply. Be respectful, but there's no need to rise when the judge enters or leaves the courtroom. You treat the virtual appearance with the same respect and decorum as if it's an in-person appearance. Ensure that you are in a separate room without any distractions. Don't sit in your car or in a busy restaurant or a cafe. I think we mentioned this in our associates meeting today. Don't sit in the car with your children present. for all appearances, especially for conferences, be settlement focused, be solution focused. Don't be problem focused, right? The court understands for the most part, especially when you have to prepare briefs or affidavits. They are well aware of what the issues are. But what your goal is to sort of these are the issues, these are problems, these are my proposed solutions. So that's a very general overview of like what you shouldn't or shouldn't do when you're in court.
Sorry, I couldn't find the unmute button. Thank you, Margie. And I told Anna, what was the one thing, Anna, I told you today in our associates meeting to tell your clients?
Don't wear jeans.
Don't wear jeans. Please, if that's one thing anyone can take away from this, if you are going to court, please do not wear jeans.
Well,
Please.
Joseph, if it's a virtual appearance, you could wear
Yeah.
pajama pants as long as
Yes,
Doesn't matter
that's
from the
true.
waist down.
yeah.
That's true.
Don't
Just
wear a Canadian tuxedo
yeah,
to
yeah,
court if
exactly.
it's
No,
virtual.
exactly. Just
You can
no
wear
jeans,
jeans, you can wear
please.
flip-flops.
Yeah, exactly, exactly. So, Margie, again, thank you so much. Extremely detailed, extremely easy to digest. Now we're gonna shift gears again. We're gonna go outside of the courtroom, and we're gonna go towards, you know, documents and deadlines, something that's been repeated heavily in this webinar, and the real difficulty again, you have the ability and the need to actually litigate and advocate yourself when you're in the courtroom. But before you even step foot in the courtroom, there are so many documents that need to be completed, and that really is what starts the process. So I'm going to hand it over to Michelle Snook to explain that further.
Yeah. Um, so yeah, we touched on it a bit with the differences in court systems and the courts across Ontario, what's required and what's not required. And honestly, I feel like I could do this full hour podcast, probably more, on all of the forms and the numbers and what's required and what's not required and what situation calls for what. So I'll try and be brief and general while also providing some helpful information. Yeah, basically knowing what forms to complete and what not to complete at the appropriate time makes a big difference in moving your case forward. It can also get you stuck if you're not completing the right documents. And understanding what document means is crucial to your success in the court system. Learn the purpose of each form that you're filing and receiving. Check whether it's procedural or substantive. Procedural documents set the stage for your case, while substantive documents affect right and obligations. From the very beginning, I'll get into just a little bit of some of the documents that you may see or will see come across your, I guess, table, desk, kitchen counter throughout the duration of a case conference or a case matter. When you're first starting out a court application, if you're starting, you're going to be starting with what's called a Form 8 application. This form is what sets out the narrative, the background, the history, everything all the important facts, the meat of your case that you want the judge to be aware of is going to be in this form. As well, then, therefore, the claims and the orders that you're seeking, the end goal is what's included in your application. That form is completed. It's served on the other side. It's required to be personally served, meaning physically handing that document to the person. You can't do it. It has to be a third party. From there, the person that receives it is called the respondent. The respondent would then be able to file a Form 10 answer, which is essentially the exact same form, but you have the opportunity to reply to the application. Depending on the claims that you're seeking in your application and in your answer will determine what other forms are required for you to complete in order to get your documents even filed with the court. For instance, if you're making a claim for parenting time or decision-making authority for your children, you're going to be completing what's called a Form 35-1 affidavit, which sets out basically your plan, your parenting plan for your children, and any important information that should be considered to support your parenting time, or to support the other side's parenting time, or to dispute the other side's parenting time. If you're making a claim for child support or spousal support, you must complete what's called a Form 13 financial statement. This document will attach your notices of assessment to it, which sets out and communicates to the other side as well as to the court what your income is, and what support a standard of living you're used to when it comes to spousal support. If you're making a claim for property or equalization or division of financial assets, you're going to be completing a Form 13-1 financial statement, which is a level up from the Form 13, much more detailed, a lot more information. These forms can take people by surprise as to how much information is required in order to complete them. They take a lot of time to do, and they're quite in depth. But when they're done properly, your information is probably before the court, you're presented well, and you're not missing anything. When it comes to case conferences, which would be the first stage that you finally get before a judge, there's a case conference, there's settlement conference, there's a trial scheduling court, there's trial, there's motions. Case conference briefs is your first one. Like Margie said, there's page limits to these documents that vary a bit court to court. In my general experience, case conference brief, you're looking at a page limit of 8 pages, which will get you stuck. We'll receive a lot of times, will be served with materials from self-represented individuals who aren't aware of the practice directions, and we get a 35-page just narrative case conference brief plus 200 pages of text messages. And to be fair, 5-10 years ago that was accepted, and they've made rules to prevent that, and that's more just to be we're trying to be as effective with the time that we have before the judge for your conferences. Settlement conferences, you get a little more information, you get 12 pages. But it's not a whole ton. So as Margie said, when it comes to knowing your filing rules, the practice directions are all accessible online. It's just if you do a simple Google Superior Court of Justice practice direction, there's a main page that you can click on that will then break it down region by region, which again, it'll give you cities so you know which region you might be within, which will then set out those practice directions. So I would encourage everyone right from the get-go, do a Google Superior Court practice directions, read that, keep it handy. I have it bookmarked in my web browser just to make sure that we do it every day, but it's always important to refresh yourself with those rules because they also change every few months. As well, your family law rules are also located online. You can access the entire family law rule book, which will give you your deadlines. Standard deadlines, such as 30 days from service for filing your answer. 10 days after being served with an answer, the applicant has the opportunity to file what's called a Form 10A reply, and you have 10 days from the date of service to file that. As we said, follow your deadlines. Court timelines are strict. However, in some circumstances, consent for late filing is an option, again, depending on courts. Some courts do not accept consent for late filing, even though it's provided from counsel. Most often when it comes to conferences, there are some courts that will not accept consent for late filing, even if the other side is agreeable to it. So general guidelines is to stay to the deadlines that are set out in the family law rules, because you never know when a court is going to tell you, actually, no, you don't get to file that. As a rule of thumb as well, if you do get consent for late filing, if the court you're dealing with does accept consent for late filing, materials cannot be accepted after 3 days by 2 p.m. That's the cutoff, unless you have a court order that specifies otherwise. Even if you're given consent for late filing, you cannot file materials 3 days by 2 p.m. And that's to make sure, basically, so that people are not serving materials on the eve of a motion or something and not providing enough time for the other side to be able to reply. What we recommend, or what we do as general practice, is to mark your dates in your calendar. The minute you're served with something, put reminders in your calendar. 30 days, I just got served with an application. I'm going to count 30 days, put it in my calendar. My answer is due this date. I have 1 week reminder, 2 week reminders, 3 week reminders. Keep your reminders in your calendar. That's going to keep you on track. Understanding that missed deadlines can delay your case or result in orders being made without you, without your input, which is a major issue and something that you should definitely be aware of. Let me see, what other topics do we got? So, some don'ts would be, like we said, we don't assume that the court's going to fix your mistakes. As we've said previously already, judges can't give you legal advice. Court staff can't tell you what arguments to make and how to complete the forms. So making sure that you're understanding the forms is important. Speaking with duty counsel, speaking to the Family Law Information Office, retaining a lawyer on a limited scope basis, making sure that you're not making very important mistakes on your documents. And lastly, don't leave things to the last minute. As I said, financial statements and other forms, but for instance, financial statements are in depth. They require a lot of information. There's a lot of disclosure that has to be gathered. So you want to make sure, like I said, when I have my 1 week, 2 week, 3 week reminders, that's because all of those documents I have in mind, I need certain documents by this date. And if I don't have these documents, I might not be able to get my materials filed on time. So making sure that you're not leaving things to the last minute is really important. As well, technology issues take into consideration. When we're filing documents, it's often online, and sometimes there can be access issues or technology issues that result in you not getting your documents filed before the court because you left it to the last minute, to the last hour, and then you go and file it, and your computer's broken, or your internet's down, or you don't have access to the portal. These are all things that are really important to make sure that you're considering when it comes to filing your documents and making sure everything gets put in on time.
Amazing. Oh, sorry. Oh,
Nope,
yeah.
you're good.
Yeah, I thought I was gonna say thank you again. Very, very comprehensive. We have received several questions. I mean, just because of time constraints, I saw one that I think can be answered, and Anna gave me the wink that she's gonna answer it, even though she didn't give me the wink that she's gonna answer it, but I'm gonna ask her anyways. So Anna, this question is for you. Is it worth to self-represent in a case conference since no decisions are made in a case conference to save money? The advice I received is hiring a lawyer for the case conference date will cost upwards of $5,000 and no decisions are made. And instead, you save your money and hire a lawyer for a settlement conference or a trial instead. Thank you. So I think what the question is speaking to is that if you are going to seek some sort of independent legal advice or some legal representation, maybe it shouldn't be at the first instance of a case conference, but rather along the lines. How would you answer that question?
I think the safest option is to, if you are going to get legal advice, get it up front and let the lawyer see what the theory of your case is and make that decision with you, right? Because if there's facts that, when argued, or sorry, not argued in a case conference, but that may put your case in a certain direction, it may be the more responsible option to have representation during that case conference with you. Or if it's, like we said before, a more simple matter where you feel confident you're able to go to that case conference yourself, then that is an option to be one of the cost saving opportunities for you.
Well, yeah, and just to add to that, hopefully your matter doesn't even get to a settlement conference. Hopefully you don't even have to go to a motion. So if you're able to resolve as soon as possible, the cost efficiency and the cost effectiveness of doing that is going to be exponential. So if you actually have the mindset of wanting to save costs, as Anna mentioned, you're better off retaining a lawyer as soon as possible because so happens you can resolve at the case conference. Maybe you can resolve even prior to the case conference. So I think the advice you received was ill-informed. You are correct, to the person who asked the question, you are correct that no substantive orders can be made by a judge unless it's on consent of the party. So a judge cannot what's called unilaterally make an order, a substantive order. They can make procedural orders, but they can't make substantive orders. unless it's on consent of the parties. And that's the same thing for a case conference and a settlement conference. But if you're able to resolve prior to, you're going to save money, regardless. So I think getting the legal advice as soon as possible. And when I say as soon as possible, as soon as you're either contemplating commencing a court application, or maybe you've been served with a court application and you're preparing your responding materials, that should be the instant. If you do have any reserve money saved up, I think that would be your best time to use it, just so you can, at least it's been discussed already, you can really gauge the merits of your case and move forward on that front. Margie, I know you unmuted. Do you have anything to add?
I agree with you both, Joseph and Anna, from the very beginning. Like I said, the theory of your case is important. If you go to a case conference, the assumption is you already have your answer or your application, your answer done. And you may not have asked for the relief that you should have been asking for, or you may be asking for relief that you shouldn't be asking for, right? So at the very, like, get a lawyer to help you with the application or the answer. So that's before a case conference. And yeah, that would be very helpful, because at the case conference as well, to your point, Joseph, you could settle there. In terms of procedural orders, sometimes a judge suggests a procedural order, but if you might not, it might not be cost effective. It might not be the right or the most cost efficient option. And a lawyer could be of assistance at a case conference and say, well, Your Honor, I appreciate your comments about that, but I think this is a more cost effective option procedurally. And that's how a lawyer could help you at a case conference as well.
Amazing. And I mean, we do have a lot more questions coming in. We are going to shift back to our materials, but we will make an effort to come back to the questions, because I see there's several questions that people have been asking, which is great, and we appreciate it. So thank you. Um, I am now going to move on back to Anna, actually. Um, Anna, when you are, if you have the option to receive professional legal advice, whether that be through duty counsel, whether that be at the first instance of being able to retain a lawyer, again, when you were served materials or you're contemplating serving materials, you know, how much emphasis should you be putting on that, professional advice that you are receiving?
A big one. I think if you can take one thing away today, it's that don't assume that self-representation means zero professional guidance, right? That could be one of the biggest mistakes that a self-rep makes. Um, this isn't the case at all. Even if you're representing yourself, having professional advice when it's available can be the difference between an organized and strategic case and one that can spiral into confusion. Ignoring advice is risky for a few reasons. The first one is that you don't know what you don't know. So, family law is full of mandatory steps, which Michelle highlighted, evidentiary requirements, deadlines, legal principles that aren't necessarily obvious. So, something that feels like common sense may be legally irrelevant, and something that you think is minor can actually be crucial. Second, judges can't fix the errors for you. So they can explain the process, but they can't guide you or your strategy or help you figure out the theory of your case. When you make arguments that aren't legally relevant, a judge can't redirect you and say, "Oh, do you actually mean this?" Right? So it's important that you have those discussions with legal counsel beforehand to help you figure out what that strategy is and what your arguments and issues of the case are. Third, procedural traps are everywhere. Improper service, missing financial disclosure, incorrect forms, errors in an affidavit. These are issues that can delay your case and also harm your credibility. And fourth, I would say there's strategic blind spots. Lawyers understand what evidence is persuasive, which issues judges prioritize, and how to frame your case to support settlement rather than escalation. So, professional advice can take many forms, whether that be a 1 hour consult, hiring a lawyer on a limited scope, speaking to duty counsel at the court, coaching you for certain appearances, attending pro bono matters or pro bono appointments, ignoring advice to save money is usually just going to cost you more down the road.
Well said, and I agree. Um, we are getting a lot of questions, and again, I'm gonna choose a couple that I think that are pretty general in a sense. Um, Michelle, I have a good one for you since since this is so not my area of expertise, and I think you'd be best suited to answer this one. So we have a question. How do I get access to case lines, so case center, after parting ways from my legal team to have the information that has been uploaded on my behalf and the opposing party's side to understand the exact documents that have been submitted?
Yeah. So number one, I would always say just email the court right away. Let them know that you need access to case center. Most often when a court matter is started, actually you're already invited to the case center file right away. You might just need to have a link to access it and set up your account. Because if you had counsel right from the beginning, it might have been an email that either went to your junk or you saw and you ignored. So I would either, you can do a search. It's the company or the organization that runs Case Center right now is called Thomson Reuters. And if you just do a Google, again, Google Thomson Reuters Case Center, and you click it, you should be able to create an account. And when you create an account, if the court has already granted you access, which like I said, they should right from the get-go, your case should already be there. And if it's not, just email the court and ask them to grant you access and they'll send you a link.
Amazing. See, I knew I knew the answer to that, but I thought it was better to come from you anyways. Before we move back to our scheduled programming, I see one more question here that I think can be answered. Um, the question is, if you get a general letter without a date to respond, how long do you have? So I'm assuming the question is in reference to maybe a letter you may have received from opposing counsel, and maybe they didn't specify a date to respond, or maybe they did specify a date to respond. Um, Margie, Anna, anyone want to take a stab?
Just respond as soon as possible. It's better to respond and say, I received your letter. I will respond by the end of the week than ignoring it. Because then if as a lawyer and if you haven't responded, that is sometimes the impetus for someone to commence a court application against you because they're not getting anywhere. So respond immediately as soon as possible. That's all.
Good answer. And now, going back to our programming for today, we do have a few more minutes, so I want to just make sure we hit all of our points. But we do appreciate the questions. Thank you so much for sending them in. Margie, I'm going to turn this to you. Um, how to communicate respectfully with judges and lawyers. I think the idea of communicating in a respectful manner goes without saying, as what the prompt says, but can you maybe just provide a couple tidbits about the best way of communicating with judges and lawyers, both in the courtroom and outside the courtroom?
So, first of all, as a lawyer who's had to deal with self-reps, I imagine, I don't know, Anna and Joseph, this, but you do. I don't speak to self-represented individuals on the phone or in person. Everything is in writing because I had to ensure that nothing is misrepresented after the fact. So that's one thing. In terms of respectfully having respectful communication with the opposing party or the opposing counsel or with judges, obviously don't yell, speak calmly, clearly, don't use accusatory language, don't interrupt, wait for your turn to speak, ask for permission to speak. You refer to the other party as the applicant or Mr. or Ms. Smith, or you could refer to the opposing counsel as Mr. or Ms. Smith. Don't call them by their first name. Don't call them by any other name. Just be respectful in that regard. Refer to the judge as your honor. Try not to speak directly to court staff. If you're asking for motion dates, for example, you ask the court, your honor, may I please get next available motion dates? Don't ask the court reporter or the court, the CSO or the registrar, anything refers directly to the judge. That's only like very brief because I know we're running out of time. Those are my quick tips.
Amazing. Thank you, Margie. And with that, I know it's already been discussed a little bit today, but can you just provide a couple resources for self-represented litigants to be able to access?
Yes, so these are the resources I provide when the Newmarket Court provided it to us as the DROs. And so when we encounter a lot of self-represented litigants as DROs, so this is what the court provided us. So there's document preparation services by law students who are supervised by family law lawyers, available at no cost to clients who qualify, and that's at the Family Justice Center, probonostudents.ca, and we will provide the links after the webinar. There's also affordable legal services available at the ASC Private Duty Counsel Project. I'll also provide the link for that after the webinar. There's limited scope services through private law firms like ours, or through, you could also find lawyers who are willing to provide such services through the Limited Scope Services Project. Again, we'll provide the link for that. And as you mentioned, there's Flick, and there's also a website called JusticeNet. It's also for individuals with low income, but for most of the free or low cost legal services, limited scope services, there is an income threshold, just so you know. Thanks.
Thanks, Margie. And when Margie notes that they will be provided after the webinar, if you are registered through Zoom to attend this webinar, you will receive a follow-up. I believe, I don't know if it's done today. It's usually done the following day. Part of our team will send what's called show notes. And as Margie's referencing, all of the links and the names of the institutions who are able to assist you in that regard, those will all be there in the show notes. So if you are registered via Zoom, you'll be able to have access to that. Unfortunately, if you're on YouTube, you won't. But in any event, we do have a laundry list of resources on our website, russellalexander.com, as well as where you're watching us on YouTube, lots of videos and referral links. So you're well equipped with knowledge on that front. And with that, thank you, the viewers on Zoom, on YouTube, for tuning into Family Law Now after hours. After this session, if you are joining us via Zoom, a brief survey will appear, allowing you to share your feedback and comments, suggestions for future topics that you'd like us to explore. And as always, your feedback is greatly, greatly appreciated. Now that you have made it to the end of this webinar, you are able to book now and be able to take advantage of this opportunity for a complimentary 20-minute consultation with one of our lawyers here at the firm. In order to take advantage of this initial consultation, a complimentary initial consultation, please contact our intake team at intake@russellalexander.com. It's two S's, two L's. And be sure to mention our after hours series in order to schedule your appointment. Also, registration is now open for our next event. It's next Tuesday at 6 o'clock, no, 5 o'clock. Managing stress during the divorce process. A really, really great seminar, really, really great team headlining that webinar. So be sure to check it out. In order to register, all you need to do is go to russellalexander.com/family law now. With that, thank you so much to our panelists today, Anna, Michelle, Margie, for sharing your insights. You are all so extremely you're so informational, so knowledgeable, and you make the hour go by very, very quickly. So I appreciate that, guys. As well as to our viewers, thank you so much for joining. We appreciate the questions. We really do, and appreciate the comments. And with that, we're done for the night. So thank you and have a great rest of the evening, everyone.